Welcome to the Cheeley Law Review. My name is Ben Burnett. My guest today is Bob Cheeley. Bob, welcome in.
Good to be with you, Ben.
When I look at your website, one of the practice areas that your firm has that I don't know a lot about is a breach of fiduciary duty. Can you define that for our audience?
Fiduciary duties arise in the context of business cases, particularly cases involving disputes among owners and partners in a business. Simply stated, fiduciary duties is what the law requires of every partner in a business, that they have to put the interests of their partners ahead of their own personal interests. So, for example, it's treating others the way you'd want to be treated, basically, the golden rule. Some people know what the golden rule is, but when it comes to business, they don't want to apply it because they see an opportunity to take advantage of a partner and to squeeze that partner out of a business if that partner doesn't have the same sort of staying power financially to go toe-to-toe with them. And so oftentimes we get calls from the weaker partner who's been squeezed out of a business by a more ruthless and stronger financially partner. Basically, under the law, every partner, particularly those who are in the position of executive officer of the company, that executive officer has the fiduciary duty to his partners and also to the corporation to put the best interests of the corporation first and over their own selfish personal interests. Basically, there's two types of fiduciary duties. One is the duty of fair dealing and good faith, and those are the two primary areas that are emphasized here.
Bob, talk about what good faith and fair dealings mean.
Well, good faith is basically putting the interest of your partner and the business ahead of your own selfish interest. Fair dealing is being transparent. In other words, a CEO of a company, maybe not a publicly traded company necessarily, but a private, closely held corporation, cannot take corporate opportunities that should come to the company and use them selfishly for his or her own benefit.
When you take a client who is potentially in a weaker position than somebody else in the company and they feel like they have been wronged, what are some of the first questions that you ask of the potential client that comes to you?
Well, once a client comes in with a situation where they've been mistreated, typically it's they've been forced out of the company. For example, I'd want to see the operating agreement that existed to see what it provided in terms of protections for governance of the company. I wanted to know if there's any provisions in the operating agreement that provide for capital calls, for example. One of the best things that a person of limited financial means can do when setting up a corporation is to make sure the operating agreement protects them by not subjecting them to capital calls, which would result in dilution of their ownership in the company. Sometimes they haven't covered that in the operating agreement, and that can lead to an opportunity down the road for the ruthless partner to step on them and squeeze them out.
So let's take this from the front end. Bob Cheeley and Ben Burnett are looking at starting a business together. What are some of the attributes that you would offer to entrepreneurs that have previously found success in order to protect themselves moving forward? And what do they need to care for within that operating agreement? Because I believe that fences make good neighbors.
That's true, and I think it's important for anyone like you going into business with a guy like me. You need to make sure that you, as a non-lawyer, find a lawyer to document the operating agreement and build in protections for you on the front end. That can solve and avoid maybe a lot of problems down the road. That's number one. Number two, an operating agreement is a lot like a prenuptial agreement. It spells out the roles of each person who's going to be in an ownership and leadership position in the company and their duties and responsibilities. And it also builds in protections. It should build in protections to cover certain situations, such as what happens if the company needs more capital. That needs to be spelled out. And a lot of times there's an idea guy and he's got a great idea for a business, but he doesn't have the money to do it. So he finds a partner that's got the finances and the financial horsepower to make the idea successful. Those two things can work well together, but this operating agreement needs to spell out a roadmap for the two to coexist peacefully and to make the business prosper, because you want to keep both the idea guy interested in pushing the business forward, but you also have to reward the guy who put in the money. But you want to make sure that the guy with the gold doesn't make all the rules. That's why you want to set it down in the operating agreement.
Well, thank you, Bob. This has been another episode of the Cheeley Law Review. See you guys next week.